Welcome to another edition of the Briefing by the IP Law Blog. I'm Scott Hervey.
And I'm Josh Escobedo.
Hey, Josh, I see you're COVID casual today.
Yeah, Scott, I thought about putting on the old suit and tie for the occasion, but I thought everyone knows how things are now. We're all working from home, so why don't we keep it casual with the viewers and stick with the old polo?
Yeah, I'm COVID casual as well today. But you know what isn't casual? The long trademark battle between Tiffany and Costco. And today we're going to be talking about the recent case, or the recent decision by the Second Circuit in that case. Josh, what can you tell us about the case?
It's been going on for quite some time, Scott. I think when I saw this opinion come down, I was surprised. What happened here was Tiffany received correspondence from one of its consumers who had visited a Costco warehouse. And what she said to Tiffany was, "Are you selling rings at Costco? Because I was just there and I saw some diamond engagement rings next to signage that said Tiffany." So Tiffany decided to look into the matter. They sent an investigative unit in and they discovered that Costco was in fact selling its unbranded rings, which, to be clear, are not produced by Tiffany, next to signage that said Tiffany, Tiffany style, Tiffany setting. And so Tiffany eventually files suit against Costco for that. And to be clear, Tiffany only filed suit for the instances where Costco was selling next to signage that said just Tiffany. They didn't file suit on the cases where it said Tiffany setting or Tiffany style. After some
Tiffany, just to make it clear for our viewers or listeners, there is a particular style of setting that is called Tiffany, right?
So Tiffany has its well-known setting, which is the six-prong setting. And there was some extensive evidence on the point that people have for over 100 years referred to this six-prong setting as a Tiffany style setting.
Right.
So, yes. And so they were trying to avoid that issue, I think. And that's why they limited it to instances where it just says Tiffany next to the ring. And so after some discovery was performed in the case, Tiffany had filed a motion for summary judgment seeking a finding that there was liability because none of the applicable factors, which come from a case called Polaroid, weighed in favor of Costco.
Polaroid, just to break in, sorry, Polaroid, the factors in Polaroid are very similar to the sleek craft factors, which are the factors we use to determine likelihood of confusion. It's Polaroid if you're in the Second Circuit, it's sleek craft if you're in the Ninth Circuit, right, Josh?
Right, and for what it's worth, it's DuPont if you're in the Federal Circuit. So, but all pretty similar and mostly overlapping. And it doesn't hurt the fact that most of them say, and we can apply any other factor that we find relevant in this instance. So the district court looks at the case and they look at the evidence and they said, "I agree with you, Tiffany. There are no disputed issues of material fact. We find that every single Polaroid factor weighs in favor of you. And as to Costco's fair use defense, that fails as a matter of law as well." And so the district court grants the summary judgment as to liability and orders the parties to proceed to trial on the issue of damages. After about another year or so of litigation, the trial takes place and eventually a judgment is entered against Costco in favor of Tiffany in the amount of approximately $21 million.
That's a lot of Costco pizza and hot dogs. I mean, that's a lot of money. So I'm pretty sure that Costco appealed that judgment, right?
They did. They appealed and they also filed multiple post-trial motions, which is why this took so long to get through the Second Circuit, because when the post-trial motions were filed with the district court, it stayed the appeal in the Second Circuit. But as we could all expect, the same district court who granted the summary judgment and then actually increased the amount of money that the jury awarded, finding that the jury's award was not insignificant, but needed to be increased to be fair to Tiffany. Of course, they denied the post-trial motions. And so the Second Circuit turned to this issue earlier this year, and they issued their ruling just about 2 weeks ago. And the Second Circuit looked at the situation and said, the district court got this wrong. They looked at the Polaroid factors and they said there are at least 3 factors where Costco has presented sufficient evidence where it should have gone to a trier of fact. And those 3 factors were actual confusion, good or bad faith use, and the sophistication of the consuming public. In other words, are people who are looking to purchase engagement rings sophisticated users? Are they going to scrutinize the product? And I think those of us who have ever looked into or purchased an engagement ring know that you don't just walk in and purchase that.
Right.
That's something you give at least some thought. Well, I think at least that's true for most of us. But so they found that that should have been an issue that went to the jury. And for the same reasons, the Second Circuit looked at the fair use defense and they said this also should have gone to a jury, not only because of the fact that Costco seems to use this to, at least in some instances, describe the product, but also because the district court only analyzed one of the 3 factors that go into a fair use analysis. And so the Second Circuit said, we have no choice but to vacate this judgment and remand the matter for another trial.
Interesting. I think that all goes back to what we were talking about the other week, that trial court should be very careful when evaluating dispositive motions in a contested trademark matter.
I think that's exactly right, Scott. I think that only in the most one-sided cases should district courts or trial courts in the state court proceedings find that there are no disputed issues of material fact in an infringement analysis. Because as we all know, except for the most one-sided of cases, there's usually at least some evidence that would cause a factor to weigh in favor of another party. And in dispositive motions, the courts are not supposed to weigh evidence. And in fact, the case law is clear. If you have to engage in a weighing process, that's a matter for a jury, not for the court.
Interesting. Well, I guess we'll check back in 5 years and see what happens the second go around at the district court level.
I guess we will, Scott.
All right. Thanks, Josh.
Thank you, Scott. Thanks for watching. If you don't want to miss any breaking IP news, you better play it safe and subscribe to our YouTube channel. And don't miss our posts on the IP Law blog either. Thank you.